Hi, my name is Ria Bindra. I work as an associate as part of our corporate team at Davidson & Co. Davidson & Co. Legal Consultants is a boutique law firm that has been established in 2008. We operate across a wide variety of practice areas, including litigation, dispute resolution, corporate and commercial work, wills and probate, employment, among others. And today I'm going to be talking to you about force majeure and what that means to you in light of the current ongoing COVID-19 pandemic. A force majeure event is an event that occurs beyond a party's control, which prevents a party from fulfilling its obligations under a contract. The underlying principle essentially is that on the occurrence of a force majeure event, a party is able to be excused from or entitled to suspend part or all of its performance under a contract. So parties are free to decide what to include in their force majeure clause as to what would constitute a force majeure event. They could either be specific, like a list, for example, an earthquake or a war, or they could be contained in a catch-all provision, such as events that are beyond the party's control. Now, when deciding what goes into a force majeure clause, it's very important for the parties to sit down together and deliberate what they anticipate to see to include in that clause, what's important to them performing their obligations under the contract, and what they would want to have as a backup in case a force majeure does occur, and that they can fall back on that clause in order to curtail any exposure they may have in the future. The effect of a force majeure clause is essentially to release a party from its obligations to pay damages or any potential liability on the occurrence of an event. Now, other effects could include termination, so a party may have a right to terminate their contract on the occurrence of a force majeure event, or to partially terminate particular performance of an obligation that is rendered impossible to perform on the occurrence of a force majeure event. In that case, the rest of the provisions of the contract, if they're unaffected by the force majeure, they would remain active and required to be fulfilled by the parties. You could also have a duty to mitigate any further losses that could accrue as a result of the occurrence of a force majeure event, and often all of these will be supplemented by a notice requirement, so that on the occurrence of a force majeure event, a party is usually required to notify the other party that a force majeure event has occurred and how it's impacted their potential performance of the contract. If a contract does not contain a force majeure clause, then you can rely on the legal provisions available to determine whether a force majeure event has occurred. In other words, the first priority of the parties should be to look at their contract, see what the terms of any force majeure clause contains, and that would be your starting point. Thereafter, in the absence of a force majeure clause, the UAE law does recognize the concept of force majeure, and it does cater to allow parties to suspend or terminate performance in the event of an occurrence of a force majeure event without being exposed to liability or damages. The criteria for a force majeure event under this UAE Civil Code are three. The first one being that the force majeure event needs to be unforeseeable at the time that the contract has been entered into. The second one is that it should be unavoidable, i.e. beyond the reasonable control of the parties. And the last one is that performance of the contract should be impossible. So it's a high threshold to fulfill, but these are the three criteria in order to start relying on the provisions of the UAE Civil Code in relation to force majeure. In the event of total impossibility in the parties' abilities to fulfill the obligations under a contract, under the provisions of UAE law, you would have an automatic right to terminate the contract. But if there's impossibility in relation to partial or temporary impossibility of the contract, the parties could decide to extinguish that part of the contract from being performed by the parties, and a creditor could have the right to rescind the contract if required. It might not be the case that parties wish to automatically terminate the contract on the occurrence of a force majeure event. Parties may wish to continue to keep the contract alive and active, and perhaps suspend performance or agree an alternative way of proceeding. In that case, it's advised and recommended for parties to sit down, negotiate, and carefully consider what's included in their force majeure clause, specifically what consequences might accrue on the occurrence of a force majeure event and what the parties' obligations are going forward. In addition, it might not be the case that on the occurrence of an event such as COVID-19, that automatically is categorized as a force majeure event under a contract. If the contract doesn't cater for the force majeure event, it might be the case that the courts investigate the matter, set aside the circumstances, evaluate it objectively, and decide that the criteria under the law allows the event that has occurred to be categorized as a force majeure event. In other words, if the contract doesn't say it's a force majeure, the courts may still decide that it is. Thank you so much for listening and taking the time. I hope you found this useful, and I encourage you and welcome you to share this with others that may find this interesting as well. Davidson & Co. would be delighted to assist you with any matters in relation to your COVID-19 concerns, whether in regards to corporate or contracts, force majeure concerns, employment, or anything else. Please do reach out to a member of our team for further assistance. Thanks again.